Oftentimes, when I'm meeting with people and we're discussing the fact that if you give money away, if you then later apply for Medicaid benefits, that the Department of Social Services is going to impose a penalty on you for having made that gift. People will say, well, Mike, but isn't it true that I can give a certain amount of money to my kids each year and not have that be counted against me? And this is a very common area of confusion for people. And it is confusing because we're dealing with two completely separate areas of the law. There is a certain amount of money that a person can gift to not only their children, but actually to anyone every year and not have it be counted as a taxable gift. Right now, in the year 2013, that's $14,000 per year. So I could give $14,000 to each of my three children. I could give $14,000 to each of my neighbors, and I'm sure they'd like me very much if I did that. I can give $14,000 away to any number of different people, and that will have no tax consequences to me or to them. However, that's a tax rule that's completely different from the rules that apply to Medicaid eligibility. For Medicaid eligibility purposes, if I make a gift of $10,000 to someone, even though that's perfectly fine from a gift tax standpoint, that will, if I have to apply for Medicaid within 5 years of having made that gift, that will disqualify me for receiving Medicaid benefits for some period of time. And the period of time is going to depend on the value of the gift. And there is a figure that the New York State Department of Health publishes each year to show us how we calculate that. In other words, what is the divisor that we use to determine, based on the value of our gift, how long are then we going to be ineligible for Medicaid benefits. And we'll talk about that computation another time. But the thing to be aware of is that in New York State, the state Medicaid reference guide directs each Department of Social Services to look through an individual's banking records, brokerage records, mutual fund records, going back for 5 years and looking to see have there been any transfers made of more than $2,000. So even though that's well below the $14,000 that the IRS says it's okay to give without any tax consequences, $2,000, if the Department of Social Services sees any kind of a transaction of that amount or higher, they're going to question it. They're going to want to know what was that withdrawal for. And if they determine that in fact it was a gift to someone or part of a gift to someone, then that computation will be done and there will be some period of ineligibility. So once again, this is another example of why the whole Medicaid eligibility area is so confusing for people. It is complex. It runs contrary to other areas of the law that many of us are familiar with. Again, important to make sure you're working with an expert when you're trying to navigate through this very complex area.